On Thursday, RSS General Secretary Dattatreya Hosabale added to the Emergency at 50 discourse and called for a discussion on the necessity of the words socialist and secular, which were added to the preamble to the Constitution during the emergency. The two words were added through the Constitution 42nd Amendment Act 1976, but this wasn't the only change that amendment had brought in. In fact, this amendment was by far and still remains the most comprehensive amendment ever made to the India's Constitution. It amended the preamble, 40 articles and the 7th schedule, and added 14 new articles to the Constitution as well. It is therefore often referred to as the mini Constitution, having altered the face of India's Constitution. The amendments made fundamental rights subservient to the directive principles of state policy, gave unbridled powers to the Parliament to amend any part of the Constitution, and restricted powers of the Supreme Court and High Courts to strike down any law which violates the Constitution of India. Through such changes, it destabilized the separation of powers, tilting the scales in favor of the ruling government. The amendment also added fundamental duties to the Constitution, which Prime Minister Narendra Modi and the Bharatiya Janata Party often emphasize on. Now, despite periodic opposition, while several of the amendments brought in by then Prime Minister Indira Gandhi were overturned through subsequent amendments and court judgments, other amendments like the fundamental duties and the changes made to the preamble, that is addition of the words socialist and secular, seem to have stood the test of time, with no political party having ever formalized a bill to bring changes to these provisions. Now, what were the changes that the 42nd Amendment brought in? Which ones remain and which ones were subsequently removed? In this video, I, Apoorva Mandhani, will answer all of these questions for you. But before I begin, I have an appeal to make to all of you to consider taking a subscription of ThePrint. In this newsroom at ThePrint, we believe in fair questioning and non-hyphenated journalism, and for this we need constant support from viewers like you. There's also a host of benefits that our subscribers get exclusively. You can see the benefits on your screens right now. You can also see the procedure to take the subscription on your screens, and we'll be adding links to these procedures in the description of this video. So do consider taking a subscription for ThePrint. Now, getting back to the video, as I mentioned, fundamental duties were added through the 42nd Amendment by inserting Article 51A to the Constitution. Originally, the 1976 amendment had included 10 such duties, calling upon citizens to respect the Constitution, the national flag, the national anthem, cherish the noble ideals of the freedom struggle, etc. You can see these on your screens right now. The Vajpayee government added to these fundamental duties in 2002 through the 86th Constitutional Amendment, calling upon parents and guardians to provide opportunities for education of his child, or as the case may be, ward between the age of 6 and 14 years. As I mentioned earlier, the fundamental duties continue to remain a part of the Constitution, even though they were added through the 42nd Amendment. Now, this 42nd Amendment also made changes to the 7th schedule of the Constitution, which deals with the division of lawmaking powers between the centre and the states. The amendment transferred 5 subjects: education, forests, weights and measures, protection of wild animals and birds, and administration of justice from the state list to the concurrent list. What this means is that both Parliament and state governments can enact laws on the subjects listed under the concurrent list, but as per Article 254, if there is a conflict between the laws, the central law will override the state law. In addition to this, another entry was added to the concurrent list, which is entry 20A, to make a new subject on family planning a part of this concurrent list. Now, 42nd Amendment also introduced Articles 323A and 323B to the Constitution, establishing tribunals. The provisions related to tribunals have also still remained a part of the Constitution. Additionally, this 1976 amendment added Articles 39A, which pertains to equal justice and free legal aid, Article 43A on participation of workers in management of industries, Article 48A, which pertains to protection and improvement of environment and safeguarding of forests and wildlife, and Article 39 Clause F, which talks about protection of children and youth. All of these provisions still find a place in the Constitution. Besides these, the 42nd Amendment also made changes to Articles 81 and 82 of the Constitution. You can see these provisions on your screens right now, but what this effectively did was it froze the number and boundaries of parliamentary constituencies, or essentially the delimitation exercise based on the 1971 census until the census taken after the year 2000 is published. The 84th Constitutional Amendment in 2001 extended these deadlines from 2000 to 2026. Now, after the emergency was lifted, Morarji Desai became India's first non-Congress Prime Minister, with the Janata Party coming to power. Indira Gandhi government had to go, and so did many of the amendments that it had introduced through the 42nd Amendment. So now let us look at the amendments that had to go. Now, the 42nd Amendment restricted the powers of the High Court only to consider constitutional validity of the state laws, and the Supreme Court had exclusive power to deal with the constitutional validity of central laws. It also added a provision requiring a minimum of 7 judges and 2/3 of majority to declare a law unconstitutional. Similar limits were imposed on high courts as well. The Constitution 43rd Amendment removed these restrictions on the judiciary. This was the Constitution 43rd Amendment Act 1977. The 42nd Amendment had added a provision allowing the Parliament to enact certain laws for dealing with anti-national activities and anti-national associations. But the 43rd Amendment said that these powers are of a sweeping nature and are capable of abuse. So this provision was also deleted. Now let's come to the 44th Amendment Act, which also did away with a lot of these changes that the 42nd Amendment had been brought, that Indira Gandhi had brought. The Statement of Objects and Reasons of the 44th Amendment said that one of the primary objects of the bill was to provide safeguards against recent experiences which have shown that fundamental rights were capable of being taken away by a transient majority. The transient majority is a phrase that the bill used. This amendment, the 44th Amendment, removed internal disturbance as a ground on which national emergency could be proclaimed. Just as a reminder, this was the provision and this was the reason that was used by Indira Gandhi to impose the emergency. Now the amendment included armed rebellion as a ground for declaring an emergency instead. The 42nd Amendment had also increased the term of the Lok Sabha and the state assemblies from 5 to 6 years. The 44th Amendment restored their term to the original 5 years. Now, the changes brought by the 42nd Amendments which were not undone by subsequent amendments, bore the brunt of a landmark Supreme Court judgment, popularly known as the Minerva Mills case. Minerva Mills was a textile mill based in Karnataka, and it was nationalized by the Congress government in the early 1970s, claiming that the affairs of the mill were being managed in a manner highly detrimental to public interest. Shareholders and creditors of the mills then approached the Supreme Court challenging the nationalization. Now, while you may think that the issues at the center of the petition don't really talk about the amendments, the 42nd Amendment essentially, I'll tell you what happened. Now, the issues at the center of the petitions pertain to the government's nationalization powers and the right to property, but it was the legendary Nani Palkhiwala who decided to use the case to challenge Gandhi's amendments instead. The key issues involved the amended Article 31C, which gave the directive principles of state policy primacy over the fundamental rights enshrined under Article 14 and 19 of the Constitution. That's a lot of jargon, but let me break it down for you. This meant that through the 42nd Amendment, after the 42nd Amendment, any laws that were made to give effect to any of the directive principles of state policy could not be struck down by a court on the basis that it violated the right to equality or the freedom of speech and expression or other freedoms under Article 19. The 42nd Amendment had also tweaked Article 368 of the Constitution, which talks about the Parliament's power to amend the Constitution. So, the 42nd Amendment gave unlimited powers to the Parliament to amend the Constitution and took away the court's power to review these amendments as well. With this amendment, the Congress government attempted to undo the landmark Keshwanand Bharti judgment, which laid down the basic structure doctrine. But the Supreme Court in the Minerva Mills verdict struck down these amendments that I just mentioned, these few amendments brought in by the Indira Gandhi government during the emergency, and these amendments which were still retained by the subsequent governments, but the Supreme Court then came down on them, and this is how the amendments, the 42nd amendments, many of them were undone But despite these 43rd and 44th amendments as well as the Supreme Court judgments, many traces of the 42nd Amendment still remain in the Constitution. That's all I have for you today. This is Apoorva Mandhani for The Print. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.